Judge Anton van Zyl is accused of going on retirement without delivering some of his judgments. According to reports, he has since been reported to the Judicial Service Commission. Mbekezeli Benjamin is a researcher and advocacy officer at Judges Matter, and he joins us now to take a look at this. Thank you very much, Mbekezeli, for your time this afternoon. What do we need to know about this particular judge?
Well, Judge van Zyl is a senior judge of the KwaZulu-Natal High Court. He retired in around 2020, so he has been a judge for some years. But the problem has been that for a number of years, at least for the last decade, he has been slow in delivering his judgments. In fact, he has the longest outstanding judgment in the entire judiciary of South Africa. So that is one big issue that I think he's now been reported to the Judicial Conduct Committee for.
How was he allowed to go on retirement?
Well, as a judge, you go on retirement by operation of law. So when you turn 70, you become what is called a judge not in active service. So it means that you are no longer taking on any new cases. You are retired from the bench, but you still remain a judge because you remain a judge for life, and which is why the Judicial Conduct Committee is still able to investigate you even when you go on retirement. The question as to why exactly he was allowed to go on retirement before he finished all of his judgments, I think that is something that will come out quite clearly in the Judicial Conduct Committee's investigations.
And that's just it. This report, rather, is by ground up, and they note that within the JCC, the complaint will be assessed as to whether it relates to impeachable misconduct or conduct that is serious but not impeachable. What is conduct that is serious but not impeachable if this is one of the longest, or his lack of delivering judgments is the longest we've seen in the history of the judiciary of South Africa?
Yeah, so the Judicial Service Commission Act sets out 3 categories of misconduct complaints against judges. The first one, which is the lowest category, is called ordinary misconduct, or just misconduct generally. And that one, if you're found guilty of that lower level misconduct, you can get a warning or a fine or a sanction. And then it goes to the second category of misconduct, which is called serious but non-impeachable. It means that the misconduct is serious but not enough to send you to impeachment and removal from office. And then the third category is the most serious form of misconduct. It's called gross misconduct. And that is where you, as a judge, if you're found guilty of this misconduct, you can be impeached from office. And in each of the 3 categories, there is an assessment that is done by the Judicial Conduct Committee. It looks at the circumstances, it looks at the level of misconduct, it looks at the actions that were taken in order to avoid that kind of misconduct, and the seriousness of the conduct in terms of the reputation and integrity of the judiciary, and then from there they determine which category it will sit. For this particular one, I think initially it will be categorized as a serious but non-impeachable, which is called a Section 17 misconduct. So there, what they will do, they will investigate the circumstances. They look at the kind of environment that Judge van Zyl was working under. They look at his own steps to ensure that the judgments were delivered, and if he is found not to have been to have contributed to the delays in the judgment, which I think they will, then they will move it to the most serious level of misconduct, which is gross misconduct, and he can be impeached.
To help, I guess, the general public assess the seriousness, right? What kind of cases was he dealing with in terms of the consequences on either people who are waiting for judgments or who are waiting for justice?
Yeah, so he had a variety of cases, one of which involved, for example, there was a NUMSA versus Dunlop case where there was a strike at the Dunlop factory in KZN, and Dunlop sued the union NUMSA to try and stop that strike and also to recover damages from the union. Judge van Zyl took, I think, 5 years in order to deliver the judgment, and even then he delivered a judgment that was later taken on appeal. When he got to the appeal court, he was harshly criticized for how slow he was in delivering that judgment. That is just one. But even if you look at a broader set, it involves criminal matters, it involves family-related matters, so there's a wide variety. And the impact that it has had, I imagine it to be very wide, because for a very long time, he has consistently been slow in delivering these judgments. And as you will recall, Dudu, the norms and standards for judicial performance say that a judge must deliver a judgment within 3 months. Mm-hmm. So if he's taken 10 years, that is extreme. And so I think there is fertile ground for him to be found guilty of gross misconduct and possibly be impeached, even though he's still on retirement.
Who is not paying attention, Mbekezeli, or who is supposed to be paying attention? This is not the first or the only judge. Perhaps his is a bit more extreme than others, but he's not the only one.
Yeah, he definitely isn't the only one. And I wouldn't, look, there's a combination of factors, and I wouldn't really put it on one. One of which we know that judges work under difficult conditions, right? The budget of the judiciary since 2016, we've seen that it has been cut gradually to the point where now it is becoming a bit of a crisis. There's also the problem of very few judges to deal with a growing population. If you look at KZN, there are about 30 judges for a population of, I think, the KZN population is about 9 million, and it has been growing over the years. So if you look at all of those factors, they contribute to a difficulty in delivering judgments or processing cases as quickly as possible. But then it falls on the judge themselves to also be sure that they deliver judgments within a reasonable time. Yes, it might not always be 3 months, but 6 months or a year is a very long time not to deliver a judgment. So there is also the blame that falls squarely on the judge, that they must also account for their own performance. You asked the question as who is not paying attention. Well, it's a little bit difficult because judges are not ordinary employees. Like an ordinary employee, they'll be called to the boss's office and they'll have a talking to, they'll have a written warning. It doesn't always work like that in the judiciary because there's the issue of judicial independence. So a judge president can't barge in and say you must deliver a judgment on X date or that date, because that violates an individual judge's independence. So there is a tension there, but this is why there is this mechanism of a Judicial Conduct Committee, where if as a judge you've taken too long to deliver a judgment, then you can be reported there, and the possibility of a fine, a possibility of suspension, a possibility of even impeachment and removal from office are all of those possibilities that are there to ensure that judges are held accountable even when they are recognized as being independent in terms of the Constitution.
Thank you very much for helping us make sense of all of that. Mbekezeli Benjamin, researcher and advocacy officer at Judges Matter.